Okay, well, welcome to our third and final of the three-part series. We've got Suzana Popovic-Montag and Jordy Atin, and we're talking about will planning, advanced will planning, and now today we're going to talk about life planning and some of the steps that are involved with that. Jordy, started off with, and I'll just start with you just to give people a little bit of an idea. We've spent the last two sessions talking about the will planning process and some of the things to consider. Interestingly, why don't we just start this session with what does it look like when you sign your will up, and what can you expect in a COVID time?
All right, so now there's basically three options for signing up your will. The old-fashioned option, which is you come and meet the lawyer at their home or in some other place, their office, if they're doing that, and using social distancing. You're all in the same room at the same time. Wills are the rare document that require wet signatures. So you can't use a digital signature. You can't use, DocuSign or anything like that. It requires a pen on paper. So that's going to be required in every case. So the option one was sort of you meet with your lawyer there and with another witness, because there's always got to be two witnesses in the presence of the person making the will maker. So you need at least three people. So that's option one. Option two is where, because of COVID, the government allowed a limit on, allowed you to be in the presence of one another by video conference. So you still need a wet signature, but the way that would look is you as the will maker, Ian, would have a copy of the will. Suzana and I would be the two witnesses. We would watch you on Zoom sign. Then you'd sign one copy of the will. Then Suzana would sign her copy of the will as a witness, and I would sign my copy of the will as a witness. And we'd put the three together. They'd each have a wet signature on them. We put the three together, and the three of them together in total is the will. So that's the way you can do it without having to be in the same physical location, but still in the presence of one another by video conference. And the problem with that, of course, is that you got to courier the originals around and put them all together. And now your document is that thick instead of that thick. And the third option is where, and it's something that we always sort of rejected as lawyers to try to do this, because we were concerned about the strict rules about signing wills. But in COVID, with these kinds of emergencies, we are occasionally sending out the original documents to the client to print out, and then they arrange for two witnesses that they're in their bubble, as it were, that they don't mind being in the presence of when they sign, and when those witnesses sign, they're in the presence. So all three people always have to be together. And but there are very, very strict rules about how wills are signed, and one little error can invalidate the will completely, even though it's seemingly insignificant. Like one of the witnesses being in another room and then coming back in. So it's very strict rules, and that's why we are cautious about doing that third option.
So Jordy, tell us, what does it look like, and you're practicing out of your home right now. What does it look like right now signing wills, and then what will it look like as the winter comes?
Well, it will likely be colder with more snow. That's my forecast for the winter. Yeah, so right now I do it in my backyard, which is nice. It's beautiful, and although today was a little chilly, but and I use paper weights because we don't want things flying around. So I'm going to use my living room and social distance with masks. It's one entrance, so we don't really use that room very often, and so it's going to be convenient that way if clients are willing to do that. Clients aren't willing to do that, which I understand. That's why we have these other two options. So we will see what people do, but I feel comfortable in doing that if I'm wearing a mask and everyone's wearing a mask and we're 10 feet away at separate tables. I'd be comfortable with that, but I'll leave that to the clients to determine.
Well, it sounds like a good plan, and it doesn't sound all that intrusive, because like you, I grew up in a home in North Toronto, and I used our living room about 4 times a year. So
Right.
it's one of those funny runes, isn't it? Okay, so okay, let's talk today. As I said, we were talking about the planning, and then we were talking about advanced planning. So that was a little nitty-gritty of the actual wills and estates piece of the puzzle. The last part we want to cover today in our time is what we've described as life planning. Joanne, do you want to start with us, Suzana, and just give us a little bit of an overview of capacity issues generally and what one can expect to need to concern themselves with when they're doing their will, and what level of capacity would be expected?
Sure, and I think we start, of course, with the fact that there is no single definition of capacity. And so you can't just point to one thing and say that is someone who's capable, that's someone who's not capable. And the reason for that is because capacity as a concept is time, situation, and decision specific. So it's going to depend upon the particular situation that an individual finds themselves in, what it is that they're actually trying to do during that time, and their surrounding circumstances. And so as a result of that, there is no simple way of saying that someone is meeting the definition of being capable. And depending on whether or not we're doing a will, or perhaps we're deciding we want to give gifts during lifetime, or we want to create a power of attorney, or we want to decide if someone's capable of managing property. Every one of those situations is going to be judged against what starts with a legal test that in many cases can also be informed by some of the medical evidence and opinions that come about by experts who might be able to opine on that as well. And so it's not as easy as it might simply be to say, I'm capable or I'm not capable. It's really going to depend on the context.
Okay, so Jordy, can we now just turn to we're going to break down the powers of attorney for property and personal care. And before you share a screen on it, maybe Suzana, you can just give us a general description of the difference between a power of attorney for property and a power of attorney for personal care. And then Jordy, maybe let's talk about some of the steps that we need to go through to obtain, to execute them, prepare and execute them, and also what are some of the clauses we want to look at. So let's start with the overview comments, Suzana, if you don't mind.
Yes, so if someone is no longer capable of making their own decisions because they have lost the capacity to do so, or perhaps, with a power of attorney for property, perhaps they're out of the jurisdiction and they want to appoint a substitute decision maker, then we're going to create a power of attorney. And a power of attorney can be for finances, so it's a power of attorney for property, or it can be a power of attorney for personal care decisions. Things like where someone's going to live, what they're going to wear, what they're going to eat, where they're going to be housed. Those kinds of decisions can also be made by a substitute decision maker when someone is not capable of making the decisions themselves. And the importance of this pre-planning is so that you can choose the individual who's ultimately going to make that determination for you when you no longer can, as opposed to having, and we'll talk about this a little bit later, a court order who's going to be your substitute decision maker. So depending on whether or not we want to create a power of attorney for property or a power of attorney for personal care, there's going to, again, be different legal tests for the requisite capacity. And of course, the documents themselves are different and serve separate purposes.
Okay, Jordy, let's talk about what we have to think about when we're doing our powers of attorney for property and personal care, and what can we expect to be asked when we're trying to give instructions to a lawyer.
Sure. So maybe I'll just share my screen, but if you just give me a second here, I will do that. So in a sense, it's a simpler set of questions for powers of attorney, because often really the only decision let's talk about financial decisions first, the only decision is who's that substitute decision maker going to be. And in a classic situation that the spouse is picked, here we have Claire Dunphy, and she's picking her spouse Phil to be the primary, the first. And the person, just so people know, the document itself is called a power of attorney, but the person who you appoint is called the attorney. People all call them, oh, I'm so-and-so's power of attorney. Well, yeah, the technical term is the attorney. So, but in this case, Phil is the attorney first. And then if Phil can't act, it's very common for people to think about alternates. And it's important because that person, Phil, might not be around to make decisions for you, or might not be willing to make decisions and act for you, because it could be an onerous job. They may be too old, things like that. And so in this case, we've got an example where they've appointed 2 other people. So, and maybe I can just address the idea of appointing 1 or more people to be your attorney for financial decisions. So each of the decisions, each of those choices, 1, 2, or 3, for example, people have their own positive and negative effects. So the advantage of having 1 person is that logistically it's quite simple. They don't have to check with anybody. They go to the bank themselves. They don't have to coordinate, etc. So logistically it's quite simple. The downside is that there's no check and balance necessarily. There's no one else looking at what this person is doing to check. And the other thing is the whole burden is really on them. And it's not unlike what we discussed with the executors, that, you know, by having more than 1, it takes some of the burden off the single person as a decision maker, or as just the burden of the, you know, the tasks at hand. So the other choice that you have if you appoint more than 1 person is this idea of joint appointment. So here we have joint, or what's called joint and several. And joint means that they have to decide together. It's unanimous, in other words. Both people have to go to the bank. If there's 2 people, they both have to sign everything, etc. The idea of joint and several is that it's an either or. So either Andy or Dylan can sign documents, can make decisions, etc. And maybe, Suzana, you want to jump in on the benefits of both of those 2 different options.
Absolutely, Jordy. And you alluded to them when we were talking about whether we have 1, 2, 3, or how many attorneys were actually appointed. But when you're in a joint and several situation, if it is, you know, just administratively or like physically impossible to have 2 people in the same room at the same time to sign documents, then a several appointment where only one of them can act would be a great alternative. Now, of course, it also means that the liability is still going to be, you know, on both of the parties for everything that's done, even if one of the attorneys is acting severally and the other one doesn't necessarily know about it. If there were to be an issue at the end of the day, everybody would be, you know, together liable for all the decisions that are made. And it's also really interesting that this can be done in a power of attorney situation, but you can't appoint executors under your will in a joint and several capacity. And that's something that I always try to keep in mind, because I've seen many instances where people have tried to do that and it's just not effective. It's just not allowed, basically, in a will situation, but it is in this kind of a substitute decision-making capacity situation.
Jordy, and Suzanne,
yeah.
sorry, go ahead. Go, you
no,
go.
no, you go, please. Go ahead, Ian.
I just noticed that also one of the other decisions, of course, compensation.
Right. So like an executor, a person acting under a power of attorney for financial decisions is entitled to be paid if they start acting, not just because they've been named, but they actually have to do something before they get paid. And it works on a similar basis from executors. They get a percentage of of the assets that are being managed for that person, as well as, you know, things that are coming into the person's, they're collecting income, for example, in some way, and they're paying out expenses for that person, like their, you know, housing expenses or their income tax. So they get paid on those bases. So that's pretty typical for a power of attorney document to include compensation for the attorneys who are appointed.
Suzana, that's always a tough decision when you're making that choice of whether you appoint attorneys or not. Can you give us some idea of what we can be looking forward to if things become contentious in the compensation piece on attorneys?
Oh, of course, Ian. When attorneys, just like when executors decide to take compensation, it simply elevates the fiduciary responsibilities and the standard that they're held to. And so if you take compensation, you're held to the, you know, what someone who's in a professional capacity as someone who makes these kinds of decisions for someone would be held to. And so when you get into arguments, and especially with family members, if you've appointed a family member who's just, been the attorney and other family members are overseeing this, just like we see in executor fights, you're going to see the same kind of things in attorney fights. If the compensation is not felt to be fair, if they're overreaching, if there are, decisions being gauged by, the benefit of hindsight afterwards, saying, well, you shouldn't have done that. You should have sold the property at this amount, for instance, or you should have held on till the market was better. There's so many opportunities to poke holes at the conduct of an attorney so that, of course, you can then try to reduce the claim for compensation.
Now, Jordy, what about clauses that sort of core clauses that we want to consider when we're dealing with both the financial and the personal care?
So maybe just let's talk about the financial ones first. So this is a pretty typical, pretty standard document, unlike the will that really varies quite a bit. A power of attorney for financial affairs, called the power of attorney for property, is pretty standard. And one of the things, there's a few key elements of a power of attorney for financial affairs. The first is typically the document is effective as soon as you sign it. And this is a part that, quite frankly, many people can't get their head around. And it makes sense because they think it's only going to be effective. They only really want it effective if they lose their mental capacity. Otherwise, why would you want somebody managing your financial affairs? It makes perfect sense, that position. However, for a few reasons, and which I'll talk about in a second, we make these, it's pretty typical to say that these documents are effective immediately, which means that if the person you've appointed goes into the bank the day after you sign this document with this original document, then the bank will recognize them to make decisions. They won't ask, are you mentally capable or not? They recognize that this document is effective as soon as you sign it. What are the reasons we do this? I'll just take you to that sort of section that I explain that to people. The reasons we recommend doing it this way is, first of all, if you said, okay, if a doctor says I'm incapable, then this is effective. Problem is the doctors are under pretty strict orders not to wade into a decision or an opinion as to whether somebody is capable of managing financial affairs. They're happy to do it when it comes to questions about ability to consent to medical treatment, et cetera. But when it comes to the legal question of whether somebody is mentally capable of managing their own financial affairs, doctors are reluctant to do that. In which case, if it's conditional on that and you can't get a doctor to do it, then you can't use the document. So that's the problem. Second of all, financial institutions are very wary of these of powers of attorney in the first place. And secondly, if they're only valid if you're mentally incapable, they want pretty good evidence of that. And they want continuing evidence of that, so that, just because you're found incapable one day doesn't mean you're incapable 2 weeks later. And so it can be a very onerous obligation. It's also being required that you've disclosed all these medical information about yourself. So privacy issues arise too if you're required to prove that. And lastly, the chance of somebody abusing your power of attorney while you're capable is probably less than the chance of them abusing it when you're incapable, when you don't know what's going on and you can't manage and you're not aware of your own financial affairs. So for those reasons, we typically recommend that it's effective immediately.
And you can see how important the choice of that attorney is going to be, because if people are having these kinds of concerns, I always warn them about the fact that, this is someone that you are authorizing to step into your shoes and to deal with everything that you have financially and do almost anything that you could otherwise do except for make a will. And so you really want to be careful you're choosing the right candidate. And if you've got concerns about them doing any of those things that Jordy just alluded to, then perhaps they're just not the right person for you to be appointing in the first place.
Yeah, and we put those acknowledgments right in the document in our way of doing it. When you make a power of attorney, you have to be aware of a few things. You have to be aware of what assets you have. If you have dependents that you are aware of, that you have to understand that you have an obligation to them. you have to understand that your attorneys, that's the people you appoint in your power of attorney, can do anything that you can do, as you said, Suzana, except they can't change your will, but anything else. They can buy property, sell property, invest, anything you can do with your assets, they can do. But as I always describe it, it's not a blank check. This doesn't say steal all my money. It says you have to manage my assets for my benefit. And you have to be loyal and honest and act with integrity. Now, that being said, the bank, if you show up and do give them instructions to sell something or buy something, they won't know whether you're doing it for the person's benefit or not. But that being said, there is this obligation on attorneys to act for the benefit of the person that made the power of attorney. They also have to keep an accounting of what they do. You can always change your power of attorney. As Suzana said, if you ever lose faith in the person you've appointed, you should immediately revoke your power of attorney. And two key features that are right in our legislation that says you have to be aware that your assets could diminish in value, and second of all, that your attorney could misuse this authority. So you're not saying yes, go ahead and misuse it. You're saying I recognize how powerful this document is.
And that goes quite a bit to the legal test about capacity. And as I said, it's a different test depending on different situations. But for the most part, the test generally is that you understand information that is relevant to the decision that you're going to make, and you can appreciate the consequences of that decision. So when you're making a power of attorney for property, you're understanding the information that Jordy just took us through in terms of what this document is capable of doing for you. And you also appreciate what might happen if someone misuses that. And that kind of dual part to the test for capacity helps us as, certainly as practitioners, when we're trying to determine whether or not clients are capable and understand what it is they're doing and the actual importance and consequences of such a document.
Jordy, are there any other clauses that you wanted to just highlight on the power of attorney for property or personal care before we move on?
Yeah, so on the property, I mean, there's some things that I'm sure your lawyers will put in that confirm your attorneys if you're incapable to deal with the CRA, for example, and to deal with litigation. So, I'm sure you'll, when you sit down with your lawyer about your power of attorney for financial, they'll go over it with you. I did want to just show briefly the power of attorney for personal care. If I can do that, let me just see if I can get that up here. And this document is different because unlike the financial one, this one doesn't kick in unless you're not capable of making a personal care decision. So remember, the financial one typically kicks in right away. This is one that only kicks in if you're incapable of making a decision about your personal care. What are those things? Those are things like healthcare, medical treatment, nutrition, shelter, clothing, hygiene, and safety. So if you're incapable of deciding what to eat or where to live, for example, that's when the person you've named, your attorney for personal care, can make that decision for you. So that's different than the financial one because our law doesn't ever allow anyone to make personal care decisions for somebody who's capable. And the last thing that we may want to just talk about, I don't know if you want to talk about it now, but it's some end of life planning and wishes that you can put into a power of attorney.
Sure. Well, let's actually, we were going to talk about that later on, but
Sure.
Let's talk about MAID and let's talk about this now because it doesn't hurt. Let's talk about, first of all, Jordy, if you wouldn't mind just talking about what you can do in your power of attorney for personal care in respect of end-of-life decisions. And then we'll just give a brief overview of the MAID legislation, and then Suzana's got some comments about the recent amendments.
Yeah, so one thing you can't put in a power of attorney is that you want to be, you want medical assisted death. You can't do that in advance, and Suzana can talk about that. What you can put in a power of attorney are specific wishes about medical treatment. So this is a sort of sample language clause that is not the same as a do not resuscitate or not the same as a no heroic measures, because what this says is that, I want to be saved, but but I don't want to spend a significant period of time in a vegetative state if I'm never going to get better. So there's a lot of wiggle room in a statement like this, because it talks about, you know, I don't want to be kept alive for a significant period of time, which is obviously a subjective question, unless there is a reasonable chance of recovery. So again, that's a subjective. So there's a fair bit of decision making that still is left to the attorney to implement these. But the idea is it's a statement of philosophy. It says, I don't want to be kept alive if I'm not going to get better, but do make sure that I'm given medication to alleviate suffering and all of those kinds of measures. But many people want this kind of clause, but many people don't. And so it's a very personal decision.
And Jordy, I have lots of people ask, you know, what the difference is between a power of attorney for personal care, a living will, and an advance directive. How do you address that in your practice?
Well, yeah, I mean, power of attorney itself is just a document that appoints a decision maker. A living will is a U.S. term that is akin to a power of attorney that also has a set of wishes as far as what you want, what kind of medical treatment, what kind of housing, if you're not able to live at home or you are able to live at home, those kinds of things. So they combine the two. Advance directive is really that. It's a statement of what you would want done, how your substitute decision maker would, how you'd want them to make decisions. So in effect, a living will is a combination of a power of attorney and an advance directive. In this case, this has both. This has the power of attorney appointing someone, as well as a statement of wishes. And it can be more substantive, more comprehensive, but that's the idea.
Okay, so I know, of course, medical assisted dying has been in the news for some time, and the legislation that came in allows for limited opportunity for able-bodied and cognitively able individuals to approach their medical practitioner, who will then take a series of steps to assess your cognition and your ability to make the decision, and then ultimately to use the medically assisted dying tools. That's all well and good. It's fairly limited. It's not, as you said earlier, it's not it doesn't give you an ability to advance direct the choice. It only gives you an ability to deal with it should you become within the definition of the act, and should you become unwell enough to make that decision, and that you're strong enough cognitively to make it independently. So that eliminates, of course, the possibility of being able to make that decision after you become cognitively frail, such as Alzheimer's or dementia. Suzana, I know that the government of Canada, as of last week, just made some changes to the, proposed some further changes to MAID. Can you just give us an overview of that? So I know it's not new legislation yet, but it's apparently on the block.
Oh, for sure. And it literally is off the presses, as you said, because it was just talked about last week. What the bill is proposing to do is to actually remove the requirement for a person's natural death to be reasonably foreseeable in order to be eligible for MAID. So one of the requirements before was that your death had to be imminent, like it was reasonably foreseeable that you wouldn't be able to survive. And then there'd be a two-part capacity test, you know, capacity at the time you're requesting MAID and a capacity at the time that it's going to actually be put into effect. And so the bill is proposing to change that. So it's removing the reasonable foreseeability of death provision. It's excluding the eligibility for individuals who are suffering only from mental illness. So before it would include those kinds of individuals, but now it's taking it out. So it's limiting it a little bit for that purpose. And it's also allowing now for the possibility of waiving the final consent requirement for eligible people who actually lose capacity from the time that they request MAID and that it's actually going to be put into effect. And that's just in recognition of the fact that there have been situations where, you know, the request is in, the experts are confirming that the individual is capable and understanding the consequences of that request. And then when it comes time to actually do it, they no longer have that capacity and can't consent on their own behalf. And so the provision is being made to accommodate that kind of a situation. And basically all of these amendments have come about as a result of a decision in the Quebec Superior Court in September of last year, which really brought about the impetus for expanding the definition and the availability of MAID for individuals in different circumstances beyond what was originally anticipated.
And I think that's right, and it's certainly beyond what the government anticipated, probably not what the courts anticipated, and I think the courts are going to continue to keep pushing that envelope to allow even more advanced directives down the road. But certainly for MAID purposes, it's a step in the right direction in terms of opening things up if you're going to be able to use the ability to medically assist in your death. Thanks very much. All right, so let's just spend a few minutes, and we don't have to get too deep into this, but let's just do a quick overview, Suzana, if you could, just on guardianships, because one of the things that always amazes me is the simplicity of the wills and powers of attorney process if it's done right, but most importantly, the power of attorney process. And Jordy and you have both gone through what is a relatively simple document that needs to be executed, properly executed. But, you know, too many of my clients, and as you said at the first seminar, Suzana, over half of Canadian adults don't have wills and powers of attorney. What is it that happens should you not have a power of attorney and you become incapable?
In that case, there is nobody who's authorized and able to take on the role right away. And so you have to actually bring an application before the court. If you need a guardian for property, then you've got to have someone actually apply for that position. They have to go through not only a court process, but a lot of documentation has to be prepared as part of that application, including a management plan. And that's quite a detailed document that takes you through and indicates what the proposed guardian is going to do to administer someone's finances and how they're going to take care of their assets and their belongings. When you have no one to make those decisions in respect of your personal care, then you're going to be seeking a guardianship for personal care from the court. And again, a court process that requires another plan, this one called a guardianship plan, that talks about the kind of care that you're going to provide to an individual, so that the whole goal of any of these plans, of these applications to the court, is having the court convinced that the applicant is the best person to be appointed to become the substitute decision maker for someone, that they're going to act in the best interests of that individual, and to convince the court that they have a plan in place to do so. And so normally, if it's going to go uncontested, then that may be a simpler process than if you ever get into a contested guardianship application where you have competing applications for the same position. You can imagine how difficult that must be for a judge having to pick between two people who I'm sure on the face of it look like very equally deserving candidates and yet can't work together and are competing for that position, and someone has to be ultimately appointed. And none of that has anything to do with what you would have wanted to be the actual result had you just turned your mind to it and taken the steps to prepare what would, relatively speaking, be so much easier, a power of attorney for property and personal care.
And of course, the underlying theme to all that too is the tremendous legal expense that you're going to undergo is tens of thousands of dollars as opposed to hundreds of dollars, typically for powers of attorney and wills, and you know, many you know, options that way. Sorry, go ahead.
And not to mention the delays. Like you can imagine if like even during COVID, for instance, where the courts were shutting down or only taking urgent applications or dealing with urgent matters, you know, is a power of attorney, a guardianship application, you're going to have to be convincing judges of the urgency of having someone appointed, because during that period of time, there is no one with authority. So you can't go to the bank and you can't sell assets. You can't deal with someone's other belongings otherwise, because there's no one with that authority to do so. And so, you know, certainly in addition to the cost, there is the delay, there is the complexity, and it just really underscores the importance of advanced planning and trying to do it while you still can, and making that decision yourself so that you're not at the mercy of some judge being convinced by someone that they're the right person for that job.
Terrific. All right, well, look, we've got one more topic I want to cover today, and Jordy, maybe you can start this discussion, is really what are life planning issues that tie in with the will planning process. Things like organ donation, genetic materials, those kinds of issues. What do you do with your clients in respect of either one of, let's just use organ donation and genetic materials. We can start with one or the other, and can you tell us a little bit about what are some of the things that you consider with your client on those important topics?
Yeah, organ donation is a common topic for many of my clients. They want to know more about it. We don't typically deal with them. First of all, we don't deal with it in the power of attorney because you can't donate your organs while you're alive, obviously. And in the will, it's often, you don't have authority over your body when you're dead. And so it's a bit of a catch-22 in that sense. It falls between two stools. And there is legislation, the Trillium Gift of Life legislation, that allows you to, on your driver's license, for example, designate your wishes as far as what you'd like done with your organs. Do you want them donated, and for what purpose? Often the doctors, even if you've signed that kind of statement, will go to the family members for their consent as well, because because they feel that's necessary and because it probably is. And so but that's where we start. We start with that. If you look at the back of your driver's license, there's a provision in there. And I think, Ian, you've done a fair bit of work on this as well to increase the visibility of this issue.
Yeah, and just to update things, actually, there's no more driver's license option. You have to do it online. And so you go to Trillium Gift of Life, and all you have to do, it takes 2 minutes, and you put in your OHIP number in Ontario, and you are able to register and choose what you want to do. And in terms of organ donation generally, it's an important topic, and one of those that, as you say, most of your clients, well, many of my clients anyway, ask about it, and I want to make sure that they've covered it. There's it's called beadonor.ca, and it's a one-click service that allows you to organ donate online. And then, as you say, what the Ontario government has done is they have always had the medical practitioner speak to the family, and ultimately the family, even though on the face of the donation, can have a very significant and sometimes an override, so to speak, but it's an important tool. Suzana, did you have anything to add on the organ donation before we talk about genetic materials?
I think I would just add that it's like so many of our estate planning conversations with our clients, it underscores the importance of transparency and communication and letting your family members know that that's your wish, because if you don't have that dialogue and they're being put to the test and terrible situation where everyone's emotions are riding overload, knowing what somebody would have want helps a lot, I think. And and it also gives an opportunity to explain if someone says, well, wait a minute, why would you want that? And many times people don't want to delve into it. It's a personal decision. They don't want to explain themselves, but having a dialogue in certain situations can certainly help, with that decision and the support of that decision, particularly if the medical people are going to be taking the family's override as a possibility.
Absolutely, thank you. Okay, so briefly, Jordy, genetic materials. Tell me a little bit about that, because that I'm sure is a topic that comes up, and more importantly, it's property, which is interesting.
Right, and it's not easy to deal with either. So often we'll put in the idea that you can, for cord blood, for example, where people have stored the cord blood for transplant purposes. You can deal with that in the will, because it's not you have control over it, but it's property. And the other one that we see is the idea of posthumously conceived children. And historically, you couldn't conceive of a child posthumously. You could have a child posthumously, but they had to be conceived while you're alive. Now with the use of genetic material, you could actually have a child that's conceived after you die. And then it's a question of whether that child counts, how to deal with that child in your will, because of course they weren't alive when you passed away. And so we have those kinds of issues as well.
And certainly something to think about before you come to see your lawyer to do your will is what you want to do with that, because that's not always top of mind. The last point, Suzana, maybe you could just briefly mention is digital assets and what is done with them, and then we'll wrap up a little early today.
Sure, yeah. So digital assets are relatively new thing that we're adding to our checklist, I think, just in recognition of the fact that so many people, most people, have a significant digital footprint, and they leave behind things that will somehow have to be dealt with, because again, they are assets, and we want to consider things like if we've got digital libraries of photos or music, or we've got web pages, we've got cryptocurrency, we've got all of bank accounts that we want to access that need passwords. So many of these assets require passwords. They require somehow to access them, so that we can then decide what to do with them, like Facebook pages, Twitter accounts. All of these things have different means by which executors may or may not have access to them, and then decide ultimately what you want done with them. So if we've got like a Facebook page, for instance, do we want that profile to continue on? Do we want our executor to actually take that profile down when we're gone? Do we want something else to be done with it? And so it's one thing to know what an individual wants done with things. It's another thing to actually access those platforms to do or try to do what it is that you've been directed by the will to do as part of the estate plan. So I think certainly I've seen many instances where we're spending a lot of time going through these different assets, talking about what we would ultimately like to do with it, and then considering who might be the best person to actually affect those wishes for us. So we know typically it would be the executor, but do we maybe want a separate individual, someone who's maybe more technically savvy or more familiar with those kinds of non-traditional assets, who might be a digital executor, for instance, who then can take different steps from what would be required of a traditional executor in order to deal with these very unique assets.
Well, that's terrific. Well, thank you, Jordy and Suzana. I think we're a few minutes early, but we're at the point where we've covered the basics of estate planning, some advanced estate planning steps, and then today, the life planning steps that come out of a wills and estates meeting with your lawyer. So we hopefully covered as much as we needed to cover, and thank you both for your time and your assistance, and thanks for those who are joining us. And we've got it on record, so it'll be available. Thanks very much. Everyone have a great day.
Thank you.
Thank
Bye-bye
you.
now.
Bye-bye now.